Okay, well, it's just about 10 o'clock here, so we'll go ahead and get this show on the road. Welcome, everyone, to Legal and Financial Basics with Alzheimer's San Diego. We're very glad to have you. Let me go ahead and see if my controls are working. Yes, great. So I am very, very pleased to be joined today by my longtime trusted colleague, Andrea Gherini, who is the other person that you see on screen here. I'll tell you a little bit more about her in a moment as we get started. My name is Amy Abrams. For those that I've not had a chance to meet before, I'm the Director of Education with Alzheimer's San Diego. I'm going to go ahead and tell you a little bit about Andrea. Get my, bear with me. I can't seem to pull up here we go. Okay, so let me tell you a little bit about our guest presenter for today. Andrea Gherini has been a lawyer for over 25 years. She graduated cum laude from the University of Southern California with her BA in history and received her JD with Dean's List honors from the Loyola Law School in Los Angeles. For the first 10 years of her practice, she represented business owners in real estate and securities matters, but she learned that her true calling was helping families with the often complicated, confusing, and emotional decisions that they confront while trying to provide for themselves, their children, or to care for a loved one who is aging or has a disability. So the mission of Ms. Gherini's practice is to listen with compassion to the needs expressed by her clients and to apply these years of professional expertise to craft individualized solutions to her clients' problems in the areas of estate planning, elder law, conservatorships, guardianships, probate, trust administration, Medi-Cal planning, and veterans benefits. It's a lot of areas of expertise. It's a lot of knowledge. We are so grateful for her support of our organization. I just want to say she is a volunteer. She is giving us her time here this morning to provide this program free of charge. We are deeply grateful to her for that. And I am gonna keep us going here. So just a couple kind of housekeeping notes about the way that the program will go here today. I do have everyone muted, at least I mean to. Something I'm learning as we go on further, as we're learning how these online programs work, is that Zoom is an imperfect technology and sometimes settings change. So I do have everyone set to be muted and for your video to be off, but occasionally videos come on, sound comes on. I'll do my best to kind of control that, but I'll ask for everyone's assistance as best you can. That just helps us sort of cut down on superfluous background noise and visual distraction during the program. Because you are muted, you will use the chat function to submit questions as we go. Ms. Gherini will be the presenter today. I will be moderating the chat. I'll be watching for your questions, and we're going to pause a couple of times as we go to answer those. So we have a pretty nice size group here today. Depending upon how many questions there are, we may need to limit some of those. So I just want to say that we remain available to answer questions one-on-one. We can stay after the program ends a little bit for some one-on-one chat. And of course, our social workers at Alzheimer's San Diego are always available to do one-on-one follow-up. So if there is a very specific question to your particular set of circumstances that we don't have an opportunity to address here today, please know that there are resources for some one-on-one follow-up, and we'll make sure that you get what you need. This program is being recorded, but only the the slide deck that you see on your screen, and our voices are being recorded. Your names and the chats where you are submitting questions, that is not being recorded. If you would like to receive a PDF copy of the slides that you see on the screen, send an email to education@alzsd.org, and we'll be happy to email you a copy. I'm going to remind you about that at the end of the program as well. And then I'll just say right now, thank you for your patience with us. We are definitely still figuring all of this out at Alzheimer's San Diego. We, like the rest of the world, have quickly adapted to this strange environment we find ourselves in. We're learning how online education works. We're doing our best to make this as seamless as possible, as distraction-free and easy for you as possible, but we know that it is imperfect. So I'll just say that if you're having some technology problems today, or you find this difficult to follow, please know we're going to have a recording available, and we can get you those slides. And again, we are available for one-on-one consultation should you need that. So that's all the kind of housekeeping stuff. And let me say, oops, sorry. Okay. So here is the agenda. Before we get started, I'm going to have Ms. Gherini kind of kick things off. But before we get started, we wanted to ask you a couple of questions to make sure that we're making the program for today relevant. And it takes a little bit of work on your part. If you click on the participants box, you'll find that that little menu up in your controls. Participants, you will see toward the bottom of that box there, you have an opportunity to raise your hand. It's a little icon that looks like this. Does everyone see that? So before we get started, we just wanted to ask, is there anyone attending this program today for whom employment considerations are a concern? If you have a diagnosis of dementia, or you're caring for someone who does, and they are still working, and this is an issue for you, would you go ahead and raise your hand with that little icon and let us know? We're just going to kind of breeze over that part of the agenda today if that is not a concern for folks. Okay. And likewise, is there anyone in the room, in the meeting here today, who is a veteran or who is caring for a veteran? If so, will you raise your hand and let us know? Okay, great. I see that we have some hands raised. Great. So we will cover that topic today. Okay, so Andrea, I'm gonna back up a little bit. Just wanted to do that little bit of technology before you got started on the agenda. I'm gonna go off camera, but I'm gonna continue to monitor the chat, and I'll break back in a little bit to help facilitate some questions.
Great. Thank you, Amy, and thank you everyone for attending. As Amy said, this is a new environment that we're all living in and struggling to make communication meaningful to people who need to hear this information. So your feedback will be helpful for us to improve what we do in the future. So please be sure and give us your feedback at the end. As Amy mentioned, the agenda starts with advanced care planning basics. Then we move into the key legal documents that are necessary, strategies for financing long-term care, and then the next steps that you should take and additional resources that are available. This presentation, which I have given many times in person, is full of information and can be somewhat overwhelming. So understand that it may be difficult for you to get everything the first time. The course is available to attend more than once. And I have notes besides your agenda slides that if people, that I can make available for Alzheimer's if they want to make that available to you, if you would think that would be helpful. So I am trying to move forward. So let's see if we can do that. There. So we're going to start with advanced care planning basics, which really is essentially planning for the what ifs across a lifespan. I think of it in terms of it being consideration about what's important to you, what your values are, and then what's about your stuff and where it ends up. But primarily we want to look at what your values are to make sure the planning meets those values. So what are the advantages of planning ahead? Clearly, it makes more sense to plan when there's not a crisis. You have an opportunity to identify your wishes, to communicate those wishes to the people who are going to be making decisions. You can establish a legal framework to ensure your wishes are honored. You can avoid decisions that are not well thought out if they're made in a crisis. One of the most important things is that planning ahead allows you to preserve eligibility for public benefits. And additionally, you avoid probate and court proceedings by taking steps to plan ahead. You get to remain the captain of your ship. You get to determine who your support team is going to be. And you have the ability to choose people who have expertise in estate planning, public benefits, and incapacity planning. So, as we look deeper into advanced planning concepts, we're going to focus on terms that I want you to understand. The first being estate planning. So estate planning really means the establishment of a plan for asset protection management, for making healthcare decisions during your life, and for the distribution of your assets on your passing. So in order to establish a plan, you need to discuss your values and your assets with your attorney. You need to review the beneficiary designations on your retirement accounts and life insurance policies. The main estate planning documents include a trust, a will, a durable power of attorney for asset management, an advanced healthcare directive, and also a waiver of the privacy laws known as the HIPAA, Health Information Portability Accountability Act, that we all seem to sign waivers every time we go into a doctor's office. But those waivers are important from the standpoint that you want doctors to talk to your family members and decision makers. The doctors are having you sign it so they can bill your insurance. So estate planning then moves on to the next defined term, which is benefits planning. And that's really an analysis of determining eligibility for public benefits. Public benefits in this area can include Medi-Cal, it can include SSI, it can include a number of the Medi-Cal programs, which we're going to talk about. The other issue in benefits planning is you want to be able to obtain eligibility without spending down all your assets. You want to reduce a share of cost in order to receive the benefits, and you want to avoid a recovery claim. The next term, special needs planning, really applies to protective planning for individuals with a developmental disability. So these are adults or children who were born with a developmental disability and receive government benefits to pay for health care or provide supplemental income. And I see our PowerPoint has changed on my screen.
Sorry about that. I'm going to try to get that back. My apologies.
Okay. No problem. But as I was saying, special needs planning is ensuring that the government benefits that a developmental disabled individual is receiving will not be lost if they inherit money from their parents or grandparents. Then the next term that we're going to look at is capacity. So capacity is somewhat of a moving target. From a lawyer's standpoint, we're looking at the capacity of a person to enter into a legal agreement. And we are looking at their understanding of the contents of the agreement. From a different view of capacity, the capacity to manage your affairs, a doctor is looking at your understanding of your financial assets and the ability to make good decisions. As I said, capacity is a moving target. People can have capacity on one day and not have it on the other day, depending, especially with this disease of dementia and Alzheimer's. So it's helpful to know that a diagnosis of dementia does not necessarily mean a person is incapacitated to sign a document. In the law, there are different levels of incapacity. One of the lowest levels of capacity is the ability to get married. You don't need very much understanding to enter into a contract of marriage. You need a higher level of capacity to enter into a financial contract. And a will or a simple trust is somewhat of a medium level of capacity. So our next term is conservatorships. And really a conservatorship is a court proceeding to place someone's person or their assets in the care and control of another person under the supervision of the court. A conservatorship sometimes becomes necessary when a person's incapacity is permanent and they have done no advance planning when they had capacity. So their family members have no ability to make financial decisions for them or to make healthcare decisions for them. Another time conservatorships become necessary is when people have done advanced planning, but the plan is no longer working. The person is not compliant because a power of attorney or an advanced planning document does not prevent a person from making unwise decisions, such as getting on a bus at the beginning of the month and gambling away all their Social Security payments. And so a advanced planning document can't protect someone in that situation, and a conservatorship becomes necessary. But for most people, having a healthcare directive, having a durable power of attorney or a trust is sufficient to prevent the necessity of a conservatorship. Okay, so that was sort of advanced planning, advanced care planning basics. And now we're going to dig a little deeper into what the documents are. And the first document that's listed here is the will, which in my mind is sort of the least important document because it only operates when you're dead, and it typically only operates under a court-supervised proceeding called probate. You can have a will without having a trust, that sets forth where all your stuff goes when you die, or you can have what's called a pour-over will that works with a trust. And the pour-over will says that if I leave anything out, if I don't title an asset in my trust, I want those assets to go into my trust and be distributed according to the terms of my trust. The trust, whoops, let me go back. The trust in California is the sort of the foundational advanced planning legal document, because in California, our probate system is expensive, and so people prefer to hold their assets in a trust to avoid probate. And a trust provides for management of your assets during your life if you become ill. It provides for you to manage your assets if you're healthy. And it also provides for the distribution of your assets when you die. So there are typically three parties in a trust. There's the person who puts their assets in the trust. They're called the trustor or the settlor or the grantor. But they're the person who creates the trust. And then there's the trustee. They own the assets that are putting in the trust and they manage it. And then the third person is the beneficiary, the person who receives the income and has the benefit of the assets in the trust. So when you're healthy, you're all of those things. You're the trustor, the trustee, and the beneficiary. And it's only when you become ill that you may stop being the trustee. You have identified who will be your successor trustee to take over and make financial decisions for you. But you'll still be the person who created the trust, the trustor, and you'll still be the beneficiary of the trust. So it's very important who you choose to be the successor trustee, because they're going to have ownership of your assets to manage for your benefit. The trust, because it's not under court supervision, is like an instruction book. And you want those instructions to be consistent with your values, particularly if you want flexibility in the future to do Medi-Cal planning. It's important that the trust has those provisions that allow the trust to be modified by your successor trustee or your spouse if you're married, and also for your trustee to be allowed to make gifts of your assets. And I'll explain that more when we get into Medi-Cal planning. The other part of a trust that is critical is funding the trust. And when I give this seminar in person, I have my visual aid. This is a box. This is the trust. And the document itself is an empty box. It only applies to assets that are put into the box. So I use these little Monopoly things. Here's your house going in the box. Here's your bank account. Here's your brokerage accounts. This is a funded trust because you've changed title to the assets and put them in the trust. It's very important that you don't create an empty box because it's useless. It doesn't apply to anything. The next document we're going to look at is the power of attorney for financial management. Excuse me. So the way a trust is an instruction book for the assets it holds, a power of attorney in some ways is also an instruction document for the assets it has control. The trust can't hold all types of assets. It doesn't hold retirement accounts. So your financial agent under a power of attorney is going to be given authority to manage those assets that you can't put into a trust, such as retirement accounts. The terms that are used in a power of attorney are agent and principal. The person creating the power of attorney is the principal. The person you're giving authority to manage is called the agent. And a power of attorney comes in various flavors. It can be immediately effective, so that when you sign it, your agent shares the authority to manage assets with you. Or it can be effective in the future. This is called a springing power of attorney. And the future power of attorney becomes effective when some event occurs. Typically, the event is a determination that the principal is incapacitated, and that incapacity is determined by a doctor's declaration. You can decide whether to have your power of attorney require 2 doctor's declarations or 1 doctor's declaration, or you can have your power of attorney drafted so it's effective immediately as to your first agent, who you have the most trust in, and maybe effective on your incapacity as to your successor agents. With respect to both trusts and powers of attorney and wills, you want to always have a backup decision maker. So you always need to designate your agent in first priority, then second, and if you're lucky enough to have a third trustworthy person, designate a third person. Powers of attorney are typically where attorneys will include their most planning for asset protection or Medi-Cal eligibility. And if this is important to you, you need to communicate that to the attorney, because not all powers of attorney are drafted similarly. Some of the important terms that a power of attorney should have if you want to have the future ability for your agent to do Medi-Cal planning is to amend a trust, to create an irrevocable trust, to allow gifting, and gifting beyond the annual exclusion amount, and to allow your agent specifically to make gifts to themselves if they're a family member. This is called self-dealing language. Because without these terms, an agent can't engage in any sort of Medi-Cal planning. The other terms that are important to consider in a power of attorney is access to online bank accounts, or the authority to encumber real property with a reverse mortgage. As you can tell, these broad powers are a license to steal in the wrong hands. And therefore, it's very important who you choose to be your agent. There's some things that you can do to protect yourself, and that would be including in your documents, whoever is serving as your agent or your successor trustee, to have them have an obligation, a duty to account to somebody else. So on an annual basis, they have to account. Maybe if you have chosen a child, they have to account to their other siblings. Or if you've chosen a friend, they have to account to a lawyer or an accountant or another trusted individual. And in that way, there's somebody sort of overseeing the person that you trust in sort of a checks and balance system. And as I said, these are terms that are not typically in a power of attorney. So it's important that you communicate your desire to the lawyer that Medi-Cal planning terms are important to you. Now the next slide talks about healthcare documents. So I'm going to try and move the slide over. Good. Healthcare documents in California are, we don't have what's called a living will. We have an advanced healthcare directive, which appoints an individual to make healthcare decisions for you when you can't communicate those wishes yourself. And within this document, you're giving that person instructions, how you want them to make decisions at the end of your life or when you are unable to communicate decisions. The choice of a healthcare agent, just like the choice of a financial agent, is important. Who you choose will affect the care you receive. And when you're picking a financial agent, you want somebody who's trustworthy, who knows the difference between your money and their money. When you're picking a healthcare agent, it's a completely different skill set. It can be the same person or it can be somebody else, but that skill set is you want somebody who knows your wishes for healthcare decisions, who can communicate with doctors, who can be an advocate with the medical profession. They should be able to be a diplomatic listener. So if a healthcare professional is promoting a certain treatment, the ability to say, help me understand how this treatment you're suggesting will honor my parents' wishes or my spouse's wishes. Whoops, let's go back. Be sure and choose successor agents so that there's always a backup. The healthcare directive is quite a broad power to the agent in the sense that they will determine what kind of living arrangements you have. If you're incapacitated, if it's a skilled nursing, if it's assisted living, if it's at home, they make the decision based on what you've said in the document as to instituting or withdrawing artificial nutrition, hydration, if you want to participate in research studies. These are all terms that can be included in the Advanced Healthcare Directive and should be included so that your agent knows what you want and can carry out your wishes. I have in my office often used a communication game with clients, and I'm going to show you the deck of cards. It's called Go Wish, and the cards have 36 statements on it. So the statements say things like, to keep my sense of humor, to maintain my dignity, to be treated the way I want. And each deck, here's another one, to be free from anxiety, to be free from pain. The purpose of the deck, in my way of thinking, is it's a communication starter. You can get these cards from Coda Alliance, and their website is included in this PowerPoint. But you play the card game with your agent, and you give them the deck of cards and let them identify what are the 10 or 15 card statements that are most important to you. And you see if that matches what you believe is most important. And if it doesn't, you have a conversation, because this person is going to be making decisions for you when you can't communicate your wishes or you're too tired or too ill. Each deck includes a wild card. And the wild card is for you to identify what's important to you that's not one of these statements. I think it helps get the conversation going with people. And the more your agent knows about your wishes, the better off they're able to carry those wishes out. And as I said, a healthcare directive really applies when you can't communicate. As long as you can communicate, the doctors and healthcare professionals are going to look to you. So the other documents on this list, the do not resuscitate and the physician's order for life-sustaining treatment, these are doctor's orders. These are not advanced healthcare directives. These are orders that you sign with your doctor. So they're different from a healthcare directive, because a healthcare directive is giving somebody authority to do something, whereas a pulse or a DNR is an order limiting what type of treatment you want. An emergency medical technician is required to honor a pulse or a DNR, but they're not required to honor a healthcare directive. And then lastly, the waiver of Health Insurance Portability and Accountability Act, the HIPAA waiver I mentioned earlier. This is, you want to make sure that all your documents allow medical personnel to talk to the agents that you have selected to be your decision makers. So the next step in all of these documents is reviewing them. I'm sure you may have every one of these documents that you have prepared with a lawyer 10 years ago, or maybe 20 years ago. And it's time to review them if there's been a significant change in somebody's health, if there's been changes in births, marriages, your son has married that woman. It's important to take a look at what your plan says. Nothing stays the same. And that happens in life as well as it happens in the law. Our laws are constantly changing in this area, which makes it necessary for you to communicate and review your plan with an attorney periodically. For example, before the tax laws started changing, many people had what's called A-B trusts, where the trust divided into two trusts on the death of the first spouse. Well, this is a very complicated procedure that is no longer necessary for tax planning. And so if you have an old trust, that would be a reason to consider updating it. Medi-Cal recovery rules changed in 2017 that made it easier for people to avoid a recovery claim by utilizing revocable living trusts, making sure their assets are funded in the trust. This December, the rules on inheriting IRAs changed. So if you have a trust where your retirement account is payable to the trust, that may prompt you to relook at that, because children can no longer inherit an IRA and stretch out the required minimum distribution over their lifetime. The other reason to take a look at your estate planning documents is making sure your assets are still all completely funded in your trust. Have you opened any bank accounts not in the name of your trust? Have you refinanced your house and the property has been taken out of your trust? These are all issues that arise that necessitate you to review your documents. Now, I think we're at a point that we have questions. Amy, have you received any questions that you would like me to address?
I have, yes. I have a question here about the difference between wills and living trusts. Is one better? Is there just a sort of a brief answer? When is a will useful versus a trust?
So if you own real property in California, you should have a trust because of the probate rules that govern the administration of a will when a person dies. Having a will always necessitate a probate, and a probate proceeding is a proceeding that may take a year and a half, and the lawyers are paid a percentage of the gross assets. That means we get paid on the debt of your house as well as the equity in your house. So to put a number to that, if you have a house that's worth $500,000, but you have a loan of $300,000 against the house, we get paid on the basis of $500,000 when that house goes through probate. If your assets, if you don't have a house, then you could consider if a will would be sufficient. And in that case, we then look at what are the value of the assets that would be transferring on your death and what your plan for those assets would be. Is that short enough?
Yes, thank you. I think that was really helpful. Another question is, if someone has no one to appoint as their power of attorney, or is lacking in financial resources for legal support, what resources are available in San Diego County?
Okay, so there is legal aid that will assist people with wills, I believe. So that's if they lack financial resources. That would be the main place that I would go to. If they lack people to serve in these capacities, typically where you go are professional fiduciaries. There is a whole career composed of people who will do this for a fee. So that's a concern to me if you say you have no money, no assets, and no one, because they don't do it for free. They need to be paid for the job. If you have no assets, you're not really too concerned about where your stuff goes when you die. You're more concerned as who's going to make these decisions for you if you become sick. And that, I think, would still require you to have a conversation with the professional fiduciary and see if your income is such that you would be able to pay them something to help you.
Okay. We will be covering some additional resources at the end of the program as well. So some of those resources that we cover might be helpful. I have a couple of questions here about the POLST form. At what point is it important to get a POLST signed and have that in place? And a related question, if my father is in a nursing home and he needed to go to the emergency room, for example, should I always have a copy of the POLST form with me? Sort of the practicalities of how it gets used.
Right, so let me answer the second question first, because I think yes, if you are the healthcare agent and your father has signed a POLST, it's supposed to follow him in his medical records, but I think you should keep a copy of it with you. So
I agree.
Because things always go wrong in a crisis. Mm-hmm. The first question, should I sign a POLST? The POLST has levels of care that you want if you are unresponsive when medical professionals arrive. And so it is geared towards all the care possible, comfort care, or all the care possible within a short amount of time to see if you improve. And I only think people need to have a POLST if they have a condition that is chronic or terminal. If you're healthy, you want care. You want CPR. But if you're not healthy, if CPR would be more damaging to you and unlikely to provide any benefit, then those are the factual situations in which you want to discuss a pulse with your doctor. And I think talking to your doctor about whether a pulse is appropriate in your situation makes the most sense, because these are clearly doctor's orders.
Mm-hmm. Great. Thank you. Yeah, we generally recommend, once that pulse is in place, distribute it to all the places in advance you think it might be relevant, but certainly maintaining copies for those unexpected trips is a good idea.
The pulse
I want to
and the
keep us on
healthcare
track.
directive, sorry, I didn't mean to speak over you, but the healthcare directive and the pulse should be distributed widely to your agents, every agent you've chosen, and keep a copy on you if you're traveling, because those are documents that, even though you may you give to your doctors, they don't seem to find their way in the file.
Right. Okay, just I'm going to give you a couple quick ones here, and then we'll keep moving in the interest of time. Just a point of clarification. Somebody asked a few minutes ago, did you say that one cannot inherit an IRA and IRA and keep it? Is that something that you...
So what I said is you can still inherit an IRA, and your children can extend the payout term for 10 years now. It used to be before December that they could inherit it and take required minimum distribution for their lifespan. They've limited that now to 10 years, and it applies only to your children. If you're leaving it to a sibling or a friend, they don't get that 10-year stretch out. They're limited to 5 years. And then there's more complicated rules if you're leaving an IRA to a trust.
Okay, thank you. One final question. Are you saying that if you have a trust, that all assets should be listed in the name of the trust, the bank accounts, the 401k, investments, etc.?
I'm saying that all assets that can be named listed in a trust should be. 401ks cannot be. They legally cannot be. Retirement accounts cannot be. Life insurance is typically not owned by a trust. But all of those other 3 types of assets, retirement accounts, 401k, IRAs, if it's appropriate, you can name individuals as the beneficiaries, or you can name the trust as a beneficiary. But that's a discussion to have with your lawyer as to what makes the most sense.
Okay. I'm going to wrap up questions for now. There are a couple of more we didn't have time to get to, but please hang on to them. We may be able to get them at the end. And I'm going to mute myself and turn it back over to Andrea.
Okay, so we will go on to the next topic, which is strategies for financing long-term care. And so let's first look at what long-term care is and is not. Long-term care is custodial care. It refers to services in care settings that provide non-medical assistance with the activities of daily living for a person with physical or cognitive disabilities. So activities of daily living, I always remember the acronym BATTED. It refers to bathing, ambulation, toileting, transferring, eating, and dressing. And eating is actually swallowing the food, not meal preparation. So needing assistance with ADLs is the criteria for getting custodial care in different facilities. Now, the care can be provided in a number of different types of facilities, like this slide shows. There are community-based care, which includes in-home care, adult day programs. PACE is an adult day program and a medical program. There are residential care, which includes board and care, assisted living, memory care. These are state licensed facilities that provide non-medical custodial care. And then there are skilled nursing facilities. These are also state licensed to provide medical care and custodial care. And the cost of long-term care, which depends on where you're receiving the care. So typically, home care, whether it's provided by a family member, is initially more affordable because it's not full-time. The adult day programs are more affordable. Then when you move in to residential care and skilled care, the price goes up in the terms of paying for it. However, we sort of make a circle back to home care, because in home care that's provided 24 hours a day, 7 days a week is probably the most expensive care and can run about $20,000 a month. So how do people pay for long-term care? It's really a combination of methods, personal savings, assets. Some people are lucky enough to have long-term care insurance. There are some financial tools available, such as a reverse mortgage. Charitable gift annuities are where you're giving assets to a charity in return for an income for your life. And then there are life insurance products where people have life insurance that can convert to a long-term care product, and if you need it, and if you never need it, it remains to be life insurance for your family members. Then there is also Medi-Cal. In California, we call it Medi-Cal. In the rest of the country, it's Medicaid, which is a government program to pay for custodial care or in-home care. And this program is really a middle-class benefit. There, lastly, are VA benefits to help pay for long-term care that we're going to talk about. Medicare and traditional health insurance does not cover long-term care. So unfortunately, you have up to about 100 days of skilled nursing care that Medicare will cover. And it's unlikely that you'll get the full 100 days. But if you do, after that, you have to use a combination of these other methods to pay for custodial care. So it's good to know that long-term care benefits are tax deductible. And I often see that people miss this on their tax return. So if you are private paying for any sort of long-term care expenses that include caregiving, home modifications, personal care items, non-covered medical expenses such as transportation, and these expenses exceed 7.5% of your adjusted gross income, that these expenses are not covered by insurance, and that the person who's incurring these expenses needs at least assistance with 2 activities of daily living. So remember, that's bathing, ambulation, transferring, toileting, eating and dressing. If a doctor says that they need at least 2 assistance with 2 activities of daily living, these out-of-pocket expenses are deductible from your income tax. So the next slide, couple of slides, have to do with employment considerations, and we're going to skip over those and go directly into veterans benefits. And the veterans benefits are very helpful to both the veteran and the caregiver. And if you are a veteran or taking care of a veteran, I suggest you go onto the VA website and look up geriatric support. And they have a very helpful website that lists a number of different programs that are not, that are available to any veteran who is in their health insurance program. You don't have to use the VA doctors. You just have to apply for the health insurance program, which is a pretty simple application. You get a VA health insurance number, and that makes you eligible for all these other programs. Besides, you get prescriptions for free, hearing aids, batteries, and can still use your private doctors if you choose. But the VA has something that's called GeriPact, and these are care teams that provide health care for veterans with more than one chronic disease and with declining mental and physical capabilities. And it's the GeriPact tries to integrate traditional healthcare services with community-based services. So they are like geriatric care managers that will assess a veteran, give recommendations to the types of programs that are available. These programs include respite programs where you can have a caregiver come into the home 3 hours, a couple of days a week, and allow the spouse or the other caregiver some time to get out of the house and do some shopping. My understanding is the availability of these programs depends on the budget during the time that you apply. But if the budget is there, the veteran doesn't pay anything for these programs. There's also subsidized daycare programs through the Glenner Center that has pickup and return home bus for daycare services. And there's also support for the caregiver. Let me go to the additional programs that are included in VA benefits include service-connected disability income. So this is if the veteran has a disability rating, they can get tax-free income based on their rating. Then there are pension benefits. The traditional pension benefit is the benefit that a veteran earns by 20 years in service. But there's also a non-service connected pension called aid and attendance. And this benefits for the veteran and the surviving spouse who needs care either in the home or in a assisted living facility, and they're using up all their income to pay for unreimbursed medical care. And if they're using all their income to pay for caregiving expenses and their assets are within a certain level, this year it's about $129,000 plus a house, they can obtain support from the VA. The veteran can receive $1,911, and if the veteran has a spouse, they can receive $2,266 a month. This program has changed over the years, It used to be a lot easier to make yourself eligible for the program, but now you can't be eligible if you give away assets for eligibility. So you can't reduce your assets without incurring a penalty that can be as much as 36 months, which this means if you give assets away to become eligible, you can't apply for 3 years. However, there are planning techniques that if your assets fall within the limit of 129,000 or less, but your income is high, there are planning techniques to reduce your income in order to become eligible for these benefits. I think our next slide tells a little bit about the VA support program. Yes. So this is what I was alluding to, the adult day health care and the homemaker and home health aid. These are programs that the VA runs, and they're not dependent on your income or your assets to become eligible for it. And I've had clients utilize these, and they can be a lifesaver in the right set of circumstances. So the well spouse can get out of the house for a few hours a week, and there's somebody that she knows is taking care of her spouse, and he or she will be safe at home. I should say he or she, as long as the woman was the veteran. These are veteran programs, so the ill person has to be a veteran. Okay, so we're going to look at Medicare for an overview so you can distinguish what Medicare is and what Medicare isn't. So Medicare is a health insurance program. It's an entitlement program. You've paid into the system by having Social Security tax deducted from your paycheck over your work history. And there's essentially 4 parts to this health insurance program. For people who are 65 and older, or people who are under 65 but receive Social Security disability income for the last 2 years, they become eligible for this health insurance program. And Part A is hospital insurance. That's free. We don't have anything deducted from our Social Security check or our charge from our income. Part B are outpatient doctor's visits. Part B you have to sign up for when you turn 65, and it will pay 80% of your outpatient and doctor's visits if you sign up for it. And then you essentially purchase a supplement that pays the other 20%. That is the typical Medicare insurance program. And Part D is a prescription drug program that you also end up signing up for when you become eligible for Medicare. Part C is an alternate program, not the traditional Medicare program where you're paying for a supplement. Instead, it is a managed care program which covers outpatient and doctor's visits and prescription drugs. So you don't pay a supplement, but there's typically some rules that you have to follow, like what doctors you can see. Medicare benefits do not cover long-term custodial care. They do cover a stay in a nursing home after the patient has had a 3-day hospital stay. So if you're in the hospital or your loved one is in the hospital for 3 days, they are going to be discharged to a skilled nursing facility for rehab. And Medicare will pay for that rehab for up to 100 days. There's typically some sort of copayment that's going to be your responsibility after day 21 to day 100. Also, after day 20, the facility must show that the patient requires skilled care to maintain their condition. Otherwise, Medicare will not cover. Oftentimes, the facilities say the patient has plateaued, so your Medicare days have run out. And that's really not the criteria anymore, but that language still exists in facilities. The criteria is if we stop giving this person skilled care 5 days a week, they will backtrack, they will fall, their health will decline. But beyond the skilled care, the rehabilitation, whether physical therapy or occupational therapy, when your Medicare coverage runs out, it does not cover custodial care. So let's distinguish between Medi-Cal and Medicare. Medi-Cal is a state program that is really a state and federal program that provides low-cost health care coverage for children and adults with limited assets and limited income. Medicare also provides for long-term care, and California's Medi-Cal program, did I say Medicare? Let me back up. Medi-Cal also provides for long-term care in California. And this is the middle-class benefit that I spoke about earlier. California's Medi-Cal program is unique because it doesn't require you to spend down all your assets to become eligible. And it also provides substantial protections for the well spouse. Medi-Cal is not typically the goal of anyone, but at the same time, there are regulations in place that will allow couples to avoid becoming impoverished if a spouse is placed in a skilled nursing facility. So Medi-Cal will pay for medically necessary healthcare services in a skilled nursing facility. Medi-Cal eligibility, generally, not just in skilled nursing facilities, but generally people are eligible for Medi-Cal if they're receiving SSI. That means that their assets are below $2,000 and their income is below $1,300 a month. Their income makes these people eligible for health insurance benefits. If their income exceeds this eligibility level, they can still get Medi-Cal, but it may be with a share of cost if they are medically needy. So Medi-Cal for long-term care is typically services in a skilled nursing facility. However, we also have in California waiver programs. So programs where Medi-Cal will be available in a different setting because it's cost efficient. And so these different settings are mentioned on this slide. In-home supportive services. If you qualify for Medi-Cal, you can get assistance in the home, and the county will pay for it. And the person from the county comes out and makes an assessment as to the number of hours you need. You can't get 24 hours a day, 7 days a week care. The most you can get is 40 hours a week. But it's all based on what you are assessed to need. Community-based adult services. So these are services within the community, such as the PACE program that has a daycare program and healthcare programs that are available to people who qualify for Medi-Cal, and they are still able to live in their home instead of in a facility. Then skilled nursing facilities are typically the institutional settings where Medi-Cal pays for benefits. And a institutional setting is a skilled nursing facility that is licensed to take Medi-Cal. So not all facilities are licensed to take Medi-Cal. And so when I said on an earlier slide that a person who has a 3-day hospital stay and then is going to be discharged to a skilled facility for rehab where Medicare is going to pay the initial period of time. This is a really important time if you are looking to be able to convert to Medi-Cal to pay for the stay in the skilled nursing facility, that you choose a facility that is licensed to take Medi-Cal. And you can find that out by going to medicare.gov and put in the name of the facilities that are being recommended to you by the hospital and see which ones are licensed to take both Medicare and Medi-Cal. Then the other last item or program on this slide is the Assisted Living Waiver Program. And the Assisted Living Waiver Program is typically a program that would pay for board and care. However, the waits are 18 months and the income requirements are that you cannot have a share of cost with your Medi-Cal, so your income has to be below the $1,300 a month. And so why the concept of the Assisted Living Waiver Program is great, it is difficult to become eligible for one of their beds in San Diego County. So eligibility, how do you become eligible for Medi-Cal? The first thing is you have to know there are various Medi-Cal programs, which I just alluded to, and their eligibility is slightly different. So what I'm talking about in this slide is the eligibility for long-term care Medi-Cal. And Medi-Cal looks at your assets and your property and puts it in 2 buckets, the exempt bucket or the non-exempt bucket, the counted bucket. So the first bucket, the exempt bucket, your home is not counted as an asset, a home of any value. Your household goods and furniture. A person can have 1 vehicle. They can have term life insurance of any amount, but they can only have life insurance with a cash value of up to $1,500. You can have burial plots, prepaid burial plans are not counted. And most importantly, a person's IRAs or 401ks are not counted as assets. Additionally, there are certain spousal protections that if you are married, your spouse can have $128,640 of assets. So in addition to all the other non-counted assets, the spouse can have $128,640, and can have income of up to $3,216 a month before the ill spouse has any share of cost in the nursing home. So you can see that this is really a middle class benefit. You can have a fair amount of assets and still become eligible for a married couple for Medi-Cal benefits. Additionally, the well spouse can keep all the retirement assets in his or her name, and they're not counted. If the ill spouse income and let me back up. If the well spouse's income in his or her own right is under the $3,216, then any income that the ill spouse has is going to be shifted and given to the well spouse so that the well spouse has at least $3,216 of income before the ill spouse will have any share of cost. But income over that amount, the ill spouse is going to have to pay all to the nursing home except for $35 a month. That's the ill spouse's share of cost. So, benefits planning. When I was talking to Amy about this slide yesterday, this is the slide that we could spend about an hour on. And we don't have an hour. We have about 15 minutes before our program ends. But so the takeaway that I want you to know that in California, when it comes to having getting Medi-Cal benefits, and especially for spouses, but even for single individuals, you can give money away in a particular manner that avoids a penalty, and thereby saving your assets and having the state of California pay for care in a nursing home. So for example, if you had $200,000, and I think, Amy, I don't know if you can do a whiteboard.
Yeah, I'll give it a try here.
Okay. Great. So you have $200,000 of assets. And if you're a single person, you can only have $2,000 of assets. So you either need to spend those down in order to become Medi-Cal eligible, or you can give them away. If you give them away all in one day, we're going to take that number and divide it by 9,337. And that comes to 21. You would not be eligible for Medi-Cal for 21 months. But if you took that $200,000 and you gave it to a child, or you put it in an irrevocable trust, and you did it in staggered gifts, and you gave the $200,000 away in gifts of $9,000 each day, and it would take you 22 days to get rid of all that money. And there would be no penalty, because there is not a penalty for giving away money under $9,337. Now, there's lots of variations on this, but I just wanted you to see visually, and now, Amy, you can go back to the, thank you very much. you don't have to give away your money to become eligible. You can pay your mortgage down. You can do improvements to your house. Since the house is exempt, you can transfer the house to an irrevocable trust or a child who's trustworthy. And then if the house is sold in the irrevocable trust, those funds will not count against the person in the skilled nursing facility. So there are a number of things to maximize maintaining assets, because if you have a person that's in a skilled nursing facility and their income is all going to their share of costs, leaving them only $35 a month, you need to strategize a way to protect some assets to pay for the things that they're going to need in the nursing home, such as clothes or hearing aids or glasses that are not covered by Medi-Cal. Then if you are a married couple, there are court proceedings that allow a married couple who has a spouse that's in a nursing home to become eligible for Medi-Cal and allow the spouse to maintain more than the 128,640 of assets and more income than $3,216 a month, because there is a strong public policy to protect the well spouse from becoming impoverished. And so courts very often, almost always, I've never had a petition denied, will move assets to the well spouse so that the ill spouse can receive Medi-Cal without disrupting the lifestyle of the well spouse. In terms of recovery, California's rules were changed in 2017 to protect people, protect heirs from recovery by the state when a family member received Medi-Cal benefits during their life. So long as the assets that are left over pass either in a revocable trust, such as a house, or pass by beneficiary designation, such as a retirement account, the state will not recover on those assets. The state will only recover against assets that go through the probate courts, which is another reason for advanced planning. You want to avoid probate. Now let me see if I go, oops. Now I'm sure you have no questions here, right? You've understood everything I said.
Believe it or not, there are a few questions. Yeah. Actually, one that just popped up, what is the difference between a revocable and an irrevocable trust?
Oh, perfect. So here's my revocable trust, my open box. You get to change it. You can change the terms. You put assets in it. You take assets out. Here's my visual aid for the irrevocable trust. You put the money in it. You don't own it. You don't manage it. You can't take the money out. But the persons you've identified can take the money out and give it to the people you've identified that you trust. It can't go to you. There has to be a trustworthy individual who receives this money and can use it for any purpose, but hopefully they use it for you. Does that help?
Yes, thank you. I have this is kind of a numbers detailed question, but it's probably one some other folks have too. On a couple of slides ago, the Medi-Cal income cap of, let's see, had uh, 2316 and 3216 income amounts. What is the 3216? Me,
Let's go back and
if
look
I
at the
can
slide.
go back. Oops.
It's 3216.
3216. Can you just describe what the MIMNA is again?
Okay, so if you're a married couple, California says that the well spouse gets to keep $3,216 of income. Gets a minimum of that. That's not the maximum. That's the minimum amount that a spouse is entitled to if the other spouse is in a skilled nursing facility. The spouse can have more than that. The spouse can keep all the income that is or that they have earned or is coming to them in their own name through retirement or pensions, but that's the minimum amount. And if they have less than that, then Medi-Cal is going to give an allocation of the ill spouse's income to the well spouse to bring them up to the minimum amount of $3,116.
Okay. Thank you.
Okay.
The example too that we did on the whiteboard,
Right.
someone had a clarifying question. They had heard that there was a $15,000 cap on gifting per year. Is that accurate?
So different rules apply in different contexts. So we're talking today about the Medi-Cal rules. And what our listener is referring to is the IRS rules on gifting without having to file a gift tax return. So the $15,000 a year, you can give away way more than that, and there's no gift tax, but you may have an obligation to file a gift tax return.
Okay. Okay.
Okay.
Let's see. In Medi-Cal eligibility, is an annuity considered exempt? This was money that was left over from the sale of a home.
Yeah, unfortunately, typically not. Annuities are considered assets. There are some Medi-Cal compliant annuities which distribute, which the asset then amount wouldn't be counted, but the income that is distributed every month from that annuity, so long as it's distributed over the person's lifetime, would count as an income and not an asset. So the short answer really is it depends on the terms of the annuity.
Okay. Okay. We're getting close on time, so I will. I'll just say there were some questions about finding out whether or not someone is eligible for the aid and attendance benefit, as well as resources for walking through the Medi-Cal application process. And I'll just say she's going to cover resources next, and there are some resources in this last portion of the presentation. So I know I'm skipping some questions, but we're going to keep moving here.
Okay. All right. So we are going to go to next steps and additional resources. Okay. So next steps. Really, this is the time we are all forced to be home and not out doing things we would normally be doing. Gather up your important documents and review them. See what your power of attorney says. Find out where the beneficiaries are on your IRAs and insurance policies, and make sure that the people that you want to be the beneficiaries. I recommend keeping all of these documents in one location and not a safe deposit box. Typically, these documents are needed when banks are closed, and you don't want to have the extra burden in a crisis of trying to get into a safe deposit box. I think your agent should know where you keep them. As to your financial documents, you don't necessarily have to give them a copy, but they should know where you keep them. These documents should also include a list of your online passwords. The beneficiary designations are really important in this environment. In 2008, when we had the last financial crisis, many financial institutions went under or merged with other banks. And when people went into the banks to try and exercise a beneficiary designation on an IRA when the owner died, if they couldn't prove that they were the beneficiary, I know US Bank, which acquired Downey Savings and Loan and Washington Mutual, was very difficult to deal with, and were insisting people probate these assets because they didn't have the beneficiary designation paperwork that they should have. So I think that that's important, that your documents include copies of your beneficiary designations. Ensure your documents will permit your agent to do government benefits planning if this is important to you. Remember, we need the trust and the power of attorney to allow gifting to the agent you trust, to potentially revoke your trust and create an irrevocable trust. And lastly, communicate your wishes to your attorney, your agent, your doctor. There is a big gap between what people say they want and what actually happens. 60% of Californians say that making sure their family is not burdened by tough decisions is extremely important. But 56% of us have not communicated our end-of-life wishes. 80% of Californians say that if they're seriously ill, they would want to talk to their physician about end-of-life decisions. But only 7% report doing so. 82% of Californians say that it's important to put their wishes in writing, but only 23% have actually done it. So if you take anything away from this lecture, please understand that your quality of life requires your planning, your communication. You need to discuss your wishes. These wishes need to be included in your estate planning documents. And don't assume that your attorney is going to know your wishes any more than you should assume that your agent will know your wishes. So let's go to the next slide, which I think is resources, or when this is a caveat. The materials that we've talked about today apply in California. California is the only state that allows gifting to become eligible for Medi-Cal. The requirements in other states are very different. The programs in other states are very different. And the laws in other states are very different. So if you're moving, you need to have counsel in the state that you're moving to. Let's go to the next slide. Here we are, resources. So the resources on this page all relate to the Advanced Healthcare Directive and the Pulse. These are great resources. The Consumer's Kit for Healthcare Advanced Planning is a questionnaire I often use in my practice and I give to clients because it allows people to focus on the medical decisions and what they would be comfortable with and what they're not. All of these things on this page, the Compassion and Choice and the Consumer Toolkit, you can download off the internet. Additionally, the person who said, you know, where do I go and I don't have any money, there's an Advanced Healthcare Directive that you can download. and complete. It requires 2 witnesses or to be notarized, which is an issue right now in our stay-at-home environment. But you don't have to pay an attorney to prepare that. I'm not saying that the ones that attorneys prepare may not be crafted more to state your wishes, but for somebody that doesn't have the funds, this is an available resource. Legal resources. Okay, so the bottom one, the California Advocates for Nursing Home Reform, is an absolutely terrific website to find out true and accurate information about Medi-Cal in California and all the different programs. The first one, National Academy of Elder Law Attorneys, which I'm a member, I think that if you're going to an elder law attorney or you have Medi-Cal issues, this is an important resource for you to look for an attorney that has dedicated their practice to these issues, as opposed to just traditional estate planning. California Elder Law Foundation provides advanced certification for elder law attorneys, and then there's the State Bar of California that we all have to be licensed by in order to practice law. The North County Bar Association has referrals for attorneys who you can talk to, and I believe they also have some low-income resources available. And then I don't know if it's on this one, but there is the San Diego County Legal Aid Society.
Andrea, this is Amy. I'm just chiming in to say I'm throwing a couple of resources into the chat,
Okay.
some links to some of these organizations that you're mentioning. So
great,
just
Elder
bring that
Law
to
and Advocacy. That's the one I was trying to remember. That's the Legal Aid Society. That is a resource for low-income individuals. Terrific. Okay, so these are the regulatory agencies for home care services, residential care facilities, skilled nursing facilities. And the bottom one is a continuing care retirement communities. These are retirement communities that you typically buy into, and then you pay a monthly service fee, and they have a continuum of service from independent to assisted to skilled nursing care. These all have places where you can, these websites, you can look to see if there are complaints against the facilities, and you can see a summary of the complaints. I know the continuing California Department of Social Services for the continuing care retirement communities, you can also see financial information about the community's health. Medicare, Medicare.gov is where you would go to look for Medicare and Medi-Cal skilled nursing facilities in your area. If you had a family member that was being discharged from a hospital and it was important to you that they went to a facility that was Medi-Cal licensed, you could go to this website and put in compare nursing homes, and it would take you to where you could see nursing homes within a certain mile radius, and you need to check the box there that you're looking at Medi-Cal licensed facilities. Medicare, the Center for Medicare Advocacy is another great site. If you have a loved one either in a hospital or in a skilled nursing facility, and they are telling you it's time to discharge, and you truly do not believe your family member is ready for discharge, they lay out in a consumer-friendly manner a way to appeal the discharge. And it's not easy in the sense that you have to have a doctor, an outside doctor, be supportive of your decision. So, but it can be done, and they'll tell you step by step on how to do it. The VA Caregiver Support Program is where I was telling you to go to find information about the different VA programs for senior veterans and their caregivers. Medi-Cal.gov, I would go to Canner instead of Medi-Cal.gov to find out about Medi-Cal. Let's see what's next. There, oh, I'm next. That's me. I thank you for the opportunity to be able to present today. I always enjoy working with Amy, and on behalf of the Alzheimer San Diego, this is a wonderful program that they have available for families who are struggling with very serious issues. So I'm available to answer some more questions if you have them. Otherwise, I turn it over to Amy.
Thank you so much. I do have there are a couple more questions that have come in the chat. So as I said, if anybody can stay a little bit longer, we'll try to address some of those individually. If you can't, I'm going to go ahead and get us wrapped up here formally. And then please just reach out to us at Alzheimer San Diego. You have Ms. Gherini's contact information, and we can talk about her free consultation services that are available at the end here. So just very briefly, Alzheimer San Diego, if you're not familiar with us, here's a brief overview of the wide array of free programs and services that are available to families that are impacted by any type of memory impairment, any form of dementia here in San Diego County. Of course, at the moment, our ability to provide in-person services is limited, but we have an array of information available on our website. We have a video library. I've received a few questions about whether or not a recording of this program will be available. And I surely hope so. If the recording turned out clean, we will post it to the website. If not, the slides are available. I'll give you instructions here in a moment on how to do that. But this is one of our core education programs. We do offer it regularly, and our social workers can also send you a list of other legal resources, the other attorneys that are on our community resource list, in addition to Andrea Gherini. We have many other great local elder law attorneys. We've got more information on advanced healthcare directives and some of these documents as well if you need them. So please reach out to our social work team by phone. You can send an email to info@alzsd.org. You can also reach someone Monday through Friday, 8:30 to 5, just via live chat. Log on to our website, and a little window will pop up, and a member of our staff is there to help if you are in need of anything right away. So what I'm going to do in the chat before we turn it over and start taking a few of these final individual questions that have been submitted, I'm going to go ahead and put into the chat now a link to a brief online survey. It just takes a minute. It's anonymous. We would love your feedback on this program. Here is the email address, education@alzsd.org. Please just drop us an email if you would like a copy of a PDF of today's slides. Again, I'm not sure that a recording will be available, but certainly the slides are available. We aren't collecting anybody's contact information because registration wasn't required for this class, so we don't know how to reach you unless you reach out and tell us that you want a copy of those slides. So please do that. information here about a couple of our next online education programs. We have a class on long distance caregiving next week, and then the following week, a program on maintaining your brain health. Both of those free as always and open to anyone. So I'm going to go ahead and put myself back on mute, and I'm going to put the link to that survey in the chat here in a moment. A question, Andrea, is whether or not, I'm going to read this, a caregiver spouse can receive Medi-Cal payments for being the caregiver for an ill spouse. I think this is a question about how IHSS works. Could you address that briefly?
Yes. So a caregiver spouse can be paid, but the ill spouse has to qualify for Medi-Cal in order to be accepted into the IHSS program. And qualifying for Medi-Cal, when you have a married couple, you can utilize those spousal impoverishment provisions or protections that I went over, so you can have more assets than a typical Medi-Cal IHS applicant would be limited to. And the well spouse can have more income, but if you otherwise qualify for Medi-Cal, you then can apply for the IHSS program, and then the well spouse will go through a certification through IHSS, and the county pays, I think it's about $12 an hour. And the number of hours, though, is based on the county's assessment of need. And there must be a requirement of assistance with activities of daily living. So in addition to just the batted, bathing, ambulation, transferring, toileting, eating, a doctor's letter will be needed that supports the care.
Great, thank you. I got a note that the link that I sent is not live, and it's a problem with Zoom. If you just copy that link and paste it in your browser, it will take you to the survey. So my apologies for that. Okay, I have a few more questions, but before I ask them, I just want to ask if you would clarify your availability for a consultation, or how folks can get, I know we provided your contact information, but what's involved in a consultation with our folks.
So I'm part of a group of lawyers in San Diego County that have agreed to provide a initial free consultation of up to an hour for Alzheimer's consumers. And my office is in Oceanside, so I'm in North County. You would call my number and say that you're an Alzheimer consumer and you want a free consultation. I oftentimes send out a questionnaire so that hour can be really useful, because you can tell a lot of the decision making relates on income and assets. But if Oceanside is not convenient for you, Amy has a list of attorneys throughout San Diego County that are willing to do the same thing.
On that note, we have a question about getting things done right now in this strange age of social distancing. If a person needs to get a power of attorney document crafted or update their estate plan, if something needs to happen urgently, what are the options right now?
So this is how I'm handling it. We are doing video meetings like this, Zoom meetings. It's important that the person who is my client, that I'm able to judge their capacity. So I may ask you to show the room they're in. We want to make sure that nobody's being unduly influenced, especially if they've never had an estate plan before. So there'll be some conversation about, who the care people are, who are the decision makers. But we are doing it. We are emailing questionnaires, as I said. We have Dropbox for you to put financial information back to us that is secure. And then the challenge is getting the documents signed. Mm-hmm. Because a power of attorney, actually, there's a couple of different types of powers of attorney. One is a statutory and one is a non-statutory. The non-statutory doesn't need a notarization. However, without a notary, it's difficult for banks to accept them. And so we can get one done that is not signed, that is effective, and then come back after this strange environment is all over, and we would acknowledge the person's signature. Same thing with a trust. A trust doesn't have to be notarized, although it's the preferred method of notarizing, of assuming the signature is accurate. So we are mailing documents out to people with instructions on how to sign them themselves, or to go to a third-party notary at a UPS store. In certain situations, because I am working at my house that is at one level, I have set out documents for people to sign that I can observe that they're signing them, which is what the notary requirement is, without us actually coming into contact with each other. So it is a struggle right now, and you have to do with what you're comfortable with. We want everyone to be safe, and we don't want anybody to take any chances.
Yes. Thank you. That's I was really interested to learn the different ways that lawyers are finding ways to make this work right now for folks. I have two more questions that I'll ask, and then we'll wrap up. Does the durable power of attorney come into play only when someone is incapacitated? The question is, if my mom and dad want me to start managing their finances now, is there some special type of document or verbiage that we need in the document? And you addressed the differences between a springing power of attorney earlier, but could you revisit that?
Sure. So let's say your parents have a perfectly good power of attorney, but it says that it's effective only on their incapacity and they want your help now. What I would recommend is that they sign a declaration that says, although I have capacity, I want my agent to start working now, and sign it. And that would take the place of any provisions that say it's only effective upon incapacity. The other way is if you're starting fresh with a new power of attorney, you would make that power of attorney effective immediately.
Okay, thank you. And I have a question here actually from the first half of the program. Could you revisit the privacy waiver and circumstances in which a person might need one? Why do we need to get a HIPAA waiver completed? When might you use that?
So your documents where you're appointing decision makers, typically they don't start their job unless the person is incapacitated. How do we prove they're incapacitated? Generally, we go to their doctor and ask for a letter that says they can no longer manage their finances. And the doctor's not going to talk to the person unless there's been a waiver, either in the trust, in the power of attorney, in the healthcare directive. Does that answer that person's question?
I hope so.
Okay.
I think she's still on the call. So
All right.
let me know if it didn't,
It
but
doesn't.
I hope that it did. Yeah. Okay, I said that would be our final two questions, but I've I've gotten two more.
Okay.
So I'll just keep doing this until Andrea says no, that's enough. We're gonna we're gonna end this. I'm teasing. I won't keep you here all day, but I have. Let me scroll back up and find it. Okay, so on the topic of gifting assets at $9,000 a day. This is a question of clarification. Is this correct? Gifting assets at $9,000 a day would avoid the waiting period for Medi-Cal benefits. That would mitigate that that waiting period. Eligibility. I'll start with that. Was that in fact what you were communicating?
So let's start with the concept that if you give assets away, you have to report to Medi-Cal the amount of assets you've given, who you've given them to, and the manner in which you've given them. That's part of the Medi-Cal application. And there are regulations, though, that say if you give assets away below a certain amount, they're not going to be counted in determining the penalty period. So there can be a penalty of up to 30 months by giving assets away. But if you give assets away below the what's called the penalty divisor, which is 9,000, I use 9,000 because it's an even number, but it's actually $9,337. Yes, you can give those assets away and become eligible for Medi-Cal sooner than if you had to either spend down the assets or if you gave a large chunk away. The concept, though, is you want to make sure that you are safeguarding the assets that you give away. You know, giving away assets and becoming impoverished to get Medi-Cal is not a good plan unless you're giving them to somebody you trust in a manner that will allow them to pay for things that otherwise you can't pay for when you're on Medi-Cal. So I don't want to encourage people to lightly give away their assets, but I want them to know that there are planning vehicles available.
Okay, thank you. I'm going to move the slides back a few here to get back to these numbers again. Okay. I have a question on just to clarify, the income cap for a married couple with one ill spouse applying for Medi-Cal that's what that 3,216 number is?
No.
Okay.
That's not the income cap. That's the income base. The least amount that the well spouse can have is 3,216. If the well spouse was still working or had a very generous pension and was getting $10,000 a month, the check in his or her name, that would not prevent the ill spouse from getting Medi-Cal.
Okay, so this is
the base.
Yes, and outside, just to reiterate, this is outside of all of those exempt assets that you talked about.
This is income. This is income. This $3,216. Okay, so now we're on assets. Mm-hmm. Different bucket than income. You can have a home, a vehicle, term life insurance, retirement accounts of any value, and And then that's a single person. Then if you're married, you can have an additional $128,000 of assets.
Great. Thank you. Let's put this back. So I do have another question here. The income cap for the well spouse. I think we're just reiterating
Yes.
Again here. That's what that minimum monthly maintenance amount is.
Allowance.
Okay.
Is the income base, not the cap. It's the minimum amount the well spouse is entitled to, not the maximum amount.
Okay. Great. Thank you so much.
Okay.
I'm going to just put contact information back up here. Please let us know if we can be of any more support. Again, if you would like a copy of the slides, send an email there. We do hope to be able to post a recording of this program to the education page of our website shortly. My profound thanks to Andrea Gherini for not only giving us your time and all your expertise here today, but giving us an extra half hour of it. Much appreciated. Pleasure. These are very complicated questions, lots of detail, and your examples and details were really helpful. Much appreciated. I'm seeing lots of thanks and appreciation in the chat box here. So I'm passing those on to you. Again, the link to that survey is in the chat there. Please fill that out. If you have another minute, we'd love to get your feedback on this program. It's anonymous, so please share openly with us. And again, my thanks to you, Andrea, for a really helpful presentation, and my hope that everybody will stay healthy and stay well, and be in touch with us at Alzheimer's San Diego if we can be of any more support.
Thank you, Amy. Have a good day, everyone.
Okay. Bye-bye.
Bye.